Good morning. I would like to call the Incarceration Prevention and Reduction Task Force Legal and Justice Systems Committee meeting to order. It is 11:29 on January 12th, 2021. And we'll start with the land acknowledgement statement. Before we begin, we acknowledge that we are gathered on the traditional and unceded territory of the Lummi, Nooksack, Samish, and Semiahmoo people who have cared for and tended this land since immemorial. Truth and acknowledgement are critical to building mutual respect and connection across all barriers of heritage and difference. We begin this effort to acknowledge what has been buried by honoring the truth. We pay respect to their elders, past and present. Please take a moment to consider the many legacies of violence, displacement, migration, and settlement that bring us together here today. And please join us in uncovering such truths at any and all public events. Okay, so we are gonna take some stuff out of order. I don't see that Angela Anderson has joined us yet. And I don't see anybody from Superior Court yet. So we've got a few things that we're missing. I was wondering, we could actually welcome Chief Tanksley. He's a new member of the Incarceration Reduction Task Force, as well as joining us here now with Legal and Justice in the Future. So thank you, Chief Tanksley, for joining us today, and welcome. And please feel free to jump in if you have any questions.
Thank you for having me. I look forward to being on this team and to see where it goes and to be as helpful as I can. I appreciate it. Great.
Sheriff Alpha, we're really hoping that Ann Deacon might be able to join us later, but she said before she didn't know how much information she'd be able to share with us. I didn't know if you were able to talk about any of future training for the new Crisis Stabilization Center for law enforcement, if you had any information on that. Did I lose Sheriff Alpha?
Can you hear me, Raylene?
I can hear you now. Thanks, Sheriff.
Yeah, I've had a lot of difficulty with the computer, so as of 5 minutes ago, it's been working now.
How good. So did you get my question, Sheriff?
I did not. I just got logged in here.
Okay, so we were hoping Ann Deacon might be able to join us a little bit later. She had another meeting, and in reference to the Crisis Stabilization Center, are you informed on any of the upcoming training for law enforcement on how they are able to use the center?
I don't believe there's anything specific on that yet, but we've been meeting for quite a time, and we're putting together direction for our deputies, and I'm sure there'll be something more formal coming out in the not too distant future.
Okay, and then will that be shared with local law enforcement and the municipalities as well?
That's correct.
Okay, so Ann might have a little more information.
Yeah, there's been a whole series of meetings with law enforcement being invited to discuss the operation and one of our biggest concerns was the ability to hold people involuntarily. And I understand at the Behavioral Health Advisory Board, or what was it? The Behavioral Health Advisory Board meeting yesterday, those concerns have been taken care of, and they're going to be able to do involuntary holds.
Excellent. Any questions on that for Sheriff Alpha with the limited amount of information we have right now? I don't see any. And Jill, can you let me know if we have anybody from Superior Court coming in or on the Pretrial Processes group?
Yes, I'll let you know. Judge Freeman, of course, was invited. He's the new Superior Court representative. I haven't heard if he is able to attend today or not.
Okay.
Raylene, this is Stephen. I'm on the work group and I could give a brief report.
That would be excellent, Stephen. Thank you.
You want me to do that now?
Stephen, I think your audio was going out. You were asking if you could do that now. And I'm just going to mention to folks my deepest apologies. I have to step off right at noon today, unfortunately. I hope to be able to get back on track with these meetings in February.
Raylene, do you want me to report now?
Yes, please. Thank you.
Okay. The Pretrial Processes work group has had several meetings over the last couple of weeks. As most of you know, Judge Garrett has retired and stepped off the bench. She's continuing on the work group, but the role of chairing that group has been passed to Judge Freeman from Superior Court. We're in a strange position and we're trying to carefully weave our way forward on this. We were interrupted on the cusp of adopting the Arnold Foundation's public safety assessment almost a year ago when the COVID restrictions hit and Superior Court shut down. We had implemented the pretrial services unit, which involved a supervisor, John Kraus, and another pretrial services officer to monitor those people who were released to the community pretrial. So there was a long break, and it was also about the time that one of the leading research institutes in pretrial processes, an organization called the Pretrial Justice Institute, or PJI, suddenly did a 180-degree reversal of their years-long endorsement of pretrial risk assessment instruments and decided that they could not endorse the use of those because of the embedded and systemic racial bias that criminal legal data carried forward from decades of racial discrimination in the United States. We tried to explore the reasoning for that. We had a conversation that was not a satisfactory explanation, but essentially the work group went dormant for quite a number of months. We since have reconvened about the same time that the Pretrial Justice Institute issued a rationale for the first time for its reversed position. That rationale was a fairly general kind of statement. The issues that it raised as a basis for its position were issues that we had identified in our work group and had taken specific steps to address and to mitigate in adopting the or in being close to adopting the PSA, or the public safety assessment. Right after the PJI rationale statement came out, there was an open letter to PJI from a raft of data scientists and academics across the country taking exception to the reasoning that they set out and basically endorsing the kind of steps that we had taken. So we can reconvened the work group and discussed whether or not we should go ahead with basically the final step on recommending to the Superior Court judicial officers that they formally adopt and start using the public safety assessment as a pretrial risk assessment instrument. In the course of that discussion, we talked with Dave Reynolds in Superior Court and John Kraus in the Pretrial Services Unit underneath Dave. And we realized that we had problems with the monitoring end of things. We had only 2 staff people. The restrictions on
Yeah,
in-person,
Kevin was gonna bring this to my speakers off here. Hold on.
the restrictions on trials and in-person meetings meant essentially that we were doing the minimal level of monitoring, regardless of whether someone would have scored low risk, moderate risk, or even high risk on the pretrial release assessment. We also realized that County Council had asked Superior Court to submit 2 budget plans, one of which was flat funding, which would keep us at 2 staff people, the other of which was to project the effects of a 7 to 9% funding reduction for Superior Court services, which would have resulted in a substantial reduction in FTEs in Superior Court and might have affected even having the 2 pretrial services unit staff. So we were faced with a practical situation where we were not for the foreseeable future likely to expand pretrial services monitoring capability. We possibly even would have less of a capability. And what we were able to provide in terms of monitoring oversight of pretrial releasees was basically impractical and inadequate to any sort of tiered oversight of people that we released. Based on that information, we decided to hold off on recommending to the judicial officers any formal adoption and implementation of the PSA for the time being, pending monitoring of financial and budgetary circumstances for the county and the Superior Court. At the same time, you may recall that about 2 years ago, the work group had invited community stakeholders, community advocates, and communities of color to meet with the work group and talk with us about the issues, which were already quite controversial at the time, involved in pretrial risk assessment of any sort. We had a community meeting. We had what they call in diplomatic circles, a frank discussion where there was considerable disagreement. And if any single position was articulated by community members, it was that we not use any pretrial risk assessment for the embedded bias concerns that they carried with them. We felt that community members deserved an update on our discussions. They deserved a fuller understanding of pretrial release decision-making, and that we wanted to, and that there were new community voices that had arisen in the community over the murder of George Floyd and the subsequent 2020 demonstrations and debates on racial bias. So we are in the process of trying to send out invitations to a second community meeting to talk about pretrial risk assessment and pretrial release and racial equity issues in the data that the courts and law enforcement use. Carol Donovan, retired Judge Garrett, and I are sort of spearheading that effort. We expect something to come out soon. We'll try to schedule something, but there's nothing definite at this point. We will certainly keep this committee and the task force as a whole updated on developments in that regard, as well as developments on how the Superior Court judicial officers choose to go forward with considering the public safety assessment or any other pretrial risk assessment. Right now, almost all pretrial defendants in Superior Court are being released with monitoring and/or bail imposed. And we're monitoring the statistics. Eric may have more to add on this. We're monitoring statistics on the failure to appear afterwards, which do not look promising, but are largely because there's little we can do about that. And the new crimes data for those people who are released. So there's a lot of tracking going on. There's a lot of sort of behind the scenes development of issues, but there's very little formal action going on in terms of pretrial release and risk assessment procedures.
Thank you, Stephen. At this time, I'd like to welcome Angela Anderson. And I think it's important to add Angela in at this point, and then we can go for questions after. She has worked for Whatcom County Public Defense team in the past and served as the chief deputy and is now currently the public defense attorney for the city of Linden. This pretrial monitoring issues have come up in the past in which there is pretrial probation services currently in the small cities for misdemeanor and gross misdemeanor charges, but there hasn't been in the past until just recently with the new work group and progress that seems to be going backwards in Superior Court. So I just wanted to have her give some enlightenment on how well it works in the municipalities and what she feels is needed in Superior Courts and anything else that she may want to add to our committee. Thank you, Angela.
Hey, everybody. It's like the good old days. I'm back on my committee. Hi, everyone. Sorry I'm late driving back from Skagit County. So, you know, I don't know where to begin. So holler at me if you've covered all of this already. But, you know, the difference between, you know, most of the small cities use district court probation for pretrial monitoring. And then we have the city of Bellingham that has the additional use of friendship diversion. Excuse me, Blaine uses friendship diversion too. The tribe, when I'm out there, they have a pretrial unit through the tribe and they have the ability to use ankle bracelet too. And then we've got the felony pretrial monitoring. So, you know, everything, COVID messes up everything. But I think what you see I mean, maybe to the chagrin of my clients, is the district court model and the friendship diversion model seem to have more contact with my clients. My felony clients are not making contact with our felony unit. And it's, I don't know what's missing. I haven't had the chance to kind of dive into that. I don't have a lot of felony clients on the felony monitoring, but it's, I mean, to be real candid, I've had them email me going, do you have updated info for your clients? I'm like, oh, I was hoping you'd be in touch with them. But I will say being on pretrial monitoring is an incentive for my clients to sort of resolve their cases sooner. That's one other positive, because they're being supervised and they ask things like, am I getting credit for this? I'm like, no, you're not, it's pretrial. So they seem to have more, you know, what's the phrase we used to use, touches with the court. And so those more touches gets them to pay more attention to the court system. I love the ability to say with like the friendship diversion that there's an alternative to incarcerating them by putting them on ankle bracelet. And I still don't think we use the resources friendship diversion has enough, that has all the GPS coordinates and all of those things that Bellingham can use. I wish the city of Linden used that more. What else can I touch on? I mean, everybody's fairly similar. There's just a few minor differences. Most effective to get people coming to court, if I had to say, I think obviously wearing an ankle bracelet. they know they need to be in court. They can't stand it. I wouldn't want it either. And it's an effective tool to get them to get things done even post plea. It is really wonderful to have the option to have the government paying for like a scram bracelet. The constant excuse I hear in Ferndale, in Linden, Judge Lewis runs out of options, and abuse is really frowned upon. So if someone's, let me step back. I'm talking like everybody knows this. If someone is using pretrial, using alcohol when they shouldn't be pretrial, what can we do to ensure their compliance with that court order? Well, you can throw them back in jail. We know we won't drink in there. That's really expensive, and that's the last resort. So we can use a TAD bracelet or a scram bracelet if those are available. District Court, I think, lost their funding for that option. So the only ones that are doing it are Blaine and Bellingham. And so then, like in Linden, we've had the judge go, look, if you can pay for private ankle bracelet that has the TAD device on it, then we'll let you stay out of jail. That's an expensive option. It's pricey for my clients. And so a lot of them don't comply or delay in complying. You don't get that immediate result. Whereas Bellingham can say, you're drinking, I'm sending you straight to FDS. You can have it on tomorrow. I've had clients at their own expense go and rent there's a mini Smart Start device that you can blow into as an alternative to the ankle bracelet. It's a lot cheaper. It works, but it buzzes every 2 hours. So clients tend to sleep through the midnight buzz where you're supposed to blow. And so then they get more pretrial violations. So I'm all about encouraging everyone to look at new technology. It's out there, it's not that expensive, and it gains compliance. And I think the cost, I'm the defense attorney, but the cost you spend monitoring them pretrial comes back to you pretty quickly because they resolve a lot faster. All right, that's my 2 cents on it, but I can tell more if people have more specific questions.
So just real quick, Angela, I wanted to let you know Everson, Sumas, and Blaine are all using Friendship Diversion Service.
Perfect.
District Court, I don't know if Bruce has more to add, but they have a pilot program that they're still using, I believe, for ankle bracelets. And we have had success with that. Also, recently, statute in the latest DUI bench book, I was trying to find it, but I don't have it up. And that allowed, if the ankle bracelets program was accepted by the WASPIC, Washington State Chiefs and Police Association, then they could get credit if they were on EHD and scram at the same time. And we actually did give credit to a recent defendant that was sentenced. He was in custody due to COVID. We knew that there was issues with the jail restrictions. So Judge Bobbing said, you've had 3 prior DUIs. I really don't want to let you out of jail, but we'll go ahead and put you on EHD. So you're incarcerated at home, and we're going to put you on scram. When he was sentenced, the judge did give him credit for time served due to the statute that was addressed in court by his defense counsel. So I don't know how much that's been widely used. As soon as I can find it, I'd be happy to share it, because it was also brought up by Attorney Rands in a recent brief as well. So that's just food for thought, something to think about that was possibly beneficial. But is there any other questions or comments for Angela on?
I want to ask you a question. That was, the judge was confining him only to his home, like serious geographic restrictions?
Yes.
Okay. And that's kind of most courts don't do that. But it is such a great alternative that we should consider asking for probably more as defense attorneys instead of leaving our clients in custody. I want to point out, I am very new to, there's a proposed rule change, and I think it got accepted, and maybe the prosecutor's office can talk to us some more about it too, that limits, it's really changed, COVID has changed the appearance of defendants at pretrial hearings. I think we're going to see even less requirements of them having to come to court. So there's that rule change where they appear at arraignment and then just at trial. And so I think we're going to see some dramatic changes in how we handle pretrial release too, just because we're going to have this long period of time where we're not seeing potentially our clients or them in court.
I agree with you, Angela. I think that was a CRLJ 3.4 that just came out from Supreme Court. And I think Darlene had her hand up and had a question. If you want to go ahead, Darlene.
Sorry, I was just going to say thank you, Angela. It's really good to hear community feedback about the bracelets, both for Scram and for GPS. We've had feedback from other public defense and from some defendants, but you don't always know all the benefits and how it's helping and how it's working in the community. So thank you for sharing that. That's really helpful.
Yeah, you're welcome. I mean, I'm seeing that, and we're talking pretrial, but I'm seeing post. I'm dealing with a situation in Linden where a client served 60 days on ankle bracelet, and the client was billed the ankle bracelet fee, which is, you know, like $150 a week. I didn't realize at the same time, then the county bills the city the actual cost of the ankle bracelet, and it's a lot of money. I mean, it's almost $4,000 for this person to do 60 days of ankle bracelet. And so there's just this big cost savings using this private company versus the jail. And so I can see how the small cities are saving a lot of money. I've heard it from you guys for a long time. Now that I'm party to it and seeing the bills, I'm just kind of shocked at the cost difference between the two organizations that run ankle bracelet post plea.
There is an increase in some respects to using the ankle bracelets, I think, just because we do see probably more pretrial monitoring out of custody than we normally would, which has to be incurred and the costs go to the city when it's pretrial. When it's post-conviction, then it's on a sliding scale based on what can be afforded by the defendant. Is there any other questions or comments at this time?
I have to step away in about 2 minutes, but I thought I heard you say, Angela, and it is just so nice to see you again. I thought I heard you say, and maybe Bruce, you could speak to this, that district court lost funding. Did I misunderstand that for Scram bracelets, alcohol monitoring? Did I mishear that?
Do you want me to address that, Angela or
Yes,
Raymond?
please, because
Yeah,
that's
okay.
the last I heard, but it was months ago.
So what happened is this. Let me give the very brief history, and I think next month, Darlene and I are on for a more thorough presentation about this particular program, these programs we're talking about, but let me just give you the brief history. We started, so first off, the program that probation is involved in is not the use of devices in lieu of incarceration. It is in lieu of a sentence. Let me put it that way. It could be for probation violations. It could be for pretrial where there's concerns about alcohol use, those kinds of things. But it's not in lieu. The program we're part of is not actually jail. A jail sentence. And there is a difference there between how the county is operating those programs and how the cities do. So just to clarify that. So the program that we're involved in 2018, which is our first year of operation, we were given $20,000, spent that. 2019, we were given $75,000 for these devices and we spent that. 2020, last year, we were given $120,000 for these devices. And what happened is by about April, let's go with May, by about the end of May, in tracking the use and the expenses, I realized all of the entire $120,000 at the current rate of expenditure, plus was committed, the entire $120,000, and that $120,000 budget limit would only be achieved by cutting off any new referrals. So since about the end of May, we cut off new referrals. We continued to spend down that account, and it ended up at about $120,000 of expenditures for last year. We did take on every month a very few new cases, but basically I had to get the expenditures down, or we were going to go well beyond the $120,000. And the use, but anyway, so that's what happened there with the money for this year. We didn't, so we spent it all pretty much, and we'll see what the final numbers is. So for 2021, for the current year, I requested and was given $200,000 to spend on this program for our current year. And so we will be getting that program implemented again. We'll be this week letting judges, prosecutors, public defenders know that does that mean that that device program will now be eligible for new enrollment. So we've had people on the program at some level all 12 months. We just ran out of money and couldn't take on new ones. And so but we've got a fresh pot of money for $200,000 for this year.
Great. Thank you for that clarification, Bruce. And my apologies that I need to step off. I see some folks stepping on. It's nice to see everyone, and I'll look back with you all next month. Take care.
Sure.
Thank you, Bruce. Thank you, Minwater. Is there any questions or comments for Angela or Stephen in reference to pretrial services and monitoring?
Not on pretrial, but I just appreciate you, Raylene, pointing out the difference between the supervision levels and what goes into the people that are monitored through the sentencing as an alternative to jail. And that involves deputies going out and checking work sites where they are, doing a lot of follow-up. So those costs, we don't make money on it. It's not a profit center. It's just the cost of doing business and the actual cost of the programming for people that probably otherwise would be in jail. Thank you.
Thank you. And I know Darlene and I have both seen cost savings as well as some of the other small cities on having people on pretrial bracelets and scram bracelets. We've also seen individuals that said that having that scram bracelet on reminded them that they weren't supposed to be drinking. And I think Darlene and Bruce are scheduled in the next month to give more of a thorough presentation on how the bracelets and programs are being used. But this was kind of more to touch on pretrial services, the need for it to be worked on more with Superior Court. I really appreciate Stephen giving us an update on where we're at, and I'm hoping that COVID won't stop it completely and that we can start to move forward. I know that we've got a change of some different people coming in. I'm sure Judge Freeman will be very beneficial as he has pro tem'd in Superior Court as well as the small municipalities for being elected into his new position in Superior Court. So hopefully he will have more feedback. Arlene, did you have any more comments on this? I can't hear you, Arlene. No, I'm sorry, Arlene. I can't hear what you're saying. No. I can read your lips. Okay, I think we're gonna move on just because I can't hear you, but if you can get your volume back, let us know and we'll bring you back in.
Can I add one more thing, Raylene? Which
Yes.
I should say is I feel like, and maybe Darlene, Eric, you, Raylene, can say, I think I've seen a lot of misdemeanors get out this year with COVID and on these pretrial services. And I think, and this is my informal study, they've been able to comply. particularly with the ankle bracelet. So I don't think we've seen that because they've been released on a monitoring device, the surge in violence, that there was a big fear that if people were getting out with DV and stuff, there'd be all, they'd go violate the order and stuff. I haven't been seeing that with my caseload, and I don't know if the prosecutors have either, but I think that at some point we should probably discuss that further, because I think that's a really good thing, is that the more we can get out that also protect the DV victims too, it's another reason to get these guys out of custody pre-trial, I guess is what I'm trying to say. Does that make sense? There was so much talk when we first started the task force. If we got people out of jail, they'd go out and commit new crimes. I think we've shown that a lot of the pretrial monitoring doesn't support that they're able to comply with that. Anyway, another 2 cents from me. So thanks, guys.
I haven't seen too much of an increase. We have seen a few repeat offenders, but our caseload is so small in comparison to district court in Bellingham. But what we have seen an increase on COVID is warrants. It's now court on Wednesday, it's more warrant Wednesday. Defendants know they're not going to be booked so much on misdemeanor charges. And so I've seen an 82% increase in the last year in warrants going up. So I don't think that has to do with the pretrial monitoring. I just don't see people coming to court as ordered.
Raylene, if I'm understanding the conversations in the pretrial processes work group correctly, the data is a little bit different in superior court cases, and I'm glad to see Maya join the call because she may have a better handle on this. But I think the failure to appear and the new crimes data was a little bit disappointing and not quite in line with what Angela just described. But I don't think, I think in the new crimes area, if I'm understanding the conversations correctly, it's more crimes in the nature of what the original charges were in the first place. So a lot of them might be drug related. We're not seeing a lot of new violent crimes, which is really what our target was in the risk assessment. Maya, am I getting that right? Or do you have any other information to add?
I don't have any statistics about recidivism after release on bail. I think that the sheriff cited some recently, and I think it was requested maybe that the prosecutor's office see what they could come up with to, but I don't have, again, I just don't have any mechanism to collect that.
Any other questions in reference to pretrial programs? Hearing none, seeing no hands raised, I would like to thank Angela for coming on. Feel free to stay and give us any more information that you think will be helpful, but you're also welcome to leave. Once again, thank you so much. I do see Ann Deacon came on, and Sheriff Elfo gave us a little bit of an information on the Crisis Service Center and training. I was wondering if you could give us any more feedback on how that's going with the new Stabilization Center, Ann.
Hello, everyone. I apologize. I don't want to repeat whatever Bill may have said. We are, to be perfectly honest, we are behind our goal for establishing the mental health stabilization program criteria. So as you know, our efforts have been to certify that side of the facility for involuntary treatment, meaning that peace officers can hold someone for up to 12 hours in that facility while waiting to be evaluated by a mental health professional and determine next steps. Compass Health has not yet gotten back from the Department of Health their certification for treatment of any kind at that facility. So they're still operating at the old facility, where our substance withdrawal management services are currently very busy in our new facility. So I would say two things. One, we have a program advisory committee of which we have both representatives from the Sheriff's Office and Bellingham Police Department right now, helping to devise the program, how we're going to facilitate direct admissions, how we're going to facilitate law enforcement, or I should say arrest and incarceration diversion, as well as hospital diversion. And until we, so certainly we're working actively there. And then once we have our first set of proposals, we're going to send that out, obviously meet with every law enforcement jurisdiction and the different fire districts to get feedback on that. And then secondly, we are very close. It sounds like 4 out of the 5 managed care organizations are willing to pay for the higher level of care of an involuntary treatment facility for mental health stabilization. And if that's the case, then we also have to work with the prosecuting attorney's office and maybe some city attorneys as well to determine under what criteria will they allow law enforcement to divert. So we have a lot of work in front of us before we start training, because we don't know what we're going to train to yet. And so I'd say over the next 6 weeks, we hope to have that figured out to the greatest extent possible. And then we'll start working with all the different municipalities to figure out what the best protocols and practices are for diversion.
Thank you, Anne. Is there any questions for Anne on this matter? Go ahead, Stephen.
Are there any particular issues with the Department of Health certification for Compass Health? If so, what are they? And if not, any educated guess on the time frame for that approval?
I think the problem was there was some right hand, left hand lack of coordination, not on our part, but sometimes things get lost in the process. And so I think that's what happened here, to be perfectly honest with you. So in terms of timeline, I'm hoping by the end of the week, but I don't know what kind of workload the Department of Health has right now. I was in contact with them in December on a regular basis, pushing for not only certification of occupancy by their by the state fire marshal, but also certification of programs. So they were well aware and waiting for the paperwork.
Excellent. Thank you so much, Anne. Any other questions?
I will say, and I don't know, yesterday the Bellingham Herald, at least online, had an article on the opening of the Crisis Stabilization Center. So if you haven't seen it, I'd go online, and hopefully it was in the hard copy as well. We are also, we took some videos of the facility, and those will be put on our website soon. And then we also have a photographer coming out later this week, and we'll also use some of those photos. So our hope is certainly to give as much information to the public as possible about the new programs. And I think the only other thing we're looking for is volunteer artists. We need people to who have some skill and talent to paint some murals on the inside of each of the bedrooms. Right now, they're very stark looking. It looks kind of institutional. The rest of the facility looks really nice, but each individual room has a bed and a night table, and that's it. Kind of stark and boring, and we really want to jazz it up. But we don't want to put pictures necessarily that people can take off the wall or whatever. But there are some great murals we could paint that would be lovely. So if you know somebody interested in maybe volunteering to provide a mural, that would be lovely.
I just want to speak up for the artists and say they should be paid for their work, and you should ask for donations to pay artists for that kind of work. That's my opinion, and I think
I
it's
like
important.
it, Maya.
There is some signed work down at Waypoint Park, if you want to take a look at that.
Oh.
Thank you. I don't see any other hands. Am I missing any other hands for Anne on the Crisis Stabilization Center? Very good. I think we're going to move to other business. And Anne, if you don't mind me putting you on the spot, I have a question for you, and you might not have the answer, but something recently came up. The law changed on competency orders, that those were done within a certain time frame once somebody was incarcerated for 14 days. And then once that competency order is done, then a restoration order can be made if they feel that's going to work. In the meantime, sometimes those individuals sit in jail for a little bit longer than that 14 days. I believe there's a law that changed that too, but when it's a misdemeanor charge, the small cities tend to eat a lot of incarceration costs that an individual should be spending the time in the hospital. Do you know any way that we can speed that process up?
So if you recall, a number of months ago, we had a visit from the State Department of Mental Health Forensic Services. And they were up for that very reason, to figure out how to improve these issues throughout the state. It resulted from the True Blood lawsuit, where the state was held accountable for significant amounts of money to expedite the processing of these cases through the system, and to ensure that they get to a competency restoration center as soon as possible. So I don't know what the state is doing, other than they've got more money going out to programs. Our county receives just under $50,000, actually about just under $100,000 a year, to provide reentry services, as well as some prevention services. So some of what we've done locally is to increase our reentry position in the jail to a full-time position. And hopefully part of that person's role can be to try to expedite the actual state process. And then the other half of the money is going to support the GRACE program, so that we can prevent some of those individuals from ever going to jail in the first place, and not having to then be put into the entire competency process. But I think the state is also trying to divert more, and so they've been very interested in our triage facility and how that might work. And if we can get people to triage instead of the jail, then that issue of, assessing for competency isn't obviously in play. So those are the things I know, but I think the state is just slow to respond. One of the other things they need to do, right now, most of the competency restoration was occurring at Western State Hospital for our people. And they've had to close some wards down there because of staffing issues, other licensing issues. And so the state is putting out money into the community for different communities to build competency centers and other types of mental health stabilization centers throughout the state. Those are long-term responses. So I don't know, other than some of the things we're doing to try to either expedite or prevent, I don't know all that the state is accomplishing. I know what they're trying to do. I just don't know how far they're getting.
Thank you, Anne. Is there any other questions or comments in reference to competency issues? Maya? Maya, you're still on mute. I think she's on the phone. Sorry, I thought she was raising her hand. Is there anybody else that has any other questions on this? I think on other business, is there anybody else that has any other business? I know this is a shorter meeting. Something to think about for the future is we're always looking to be able to give the index committee information on what we want for data from the Legal and Justice Committee to be collected, so we can make sure the programs that we have in place are able to get the statistics to back that up. I know Eric Ritchie and I have talked about the new program coming up, software that might be able to give us better racial and ethnicity data. At least we're hoping for that, but I know that's going to be an ongoing struggle. But any other data that you guys want to see in the future, we want to make sure we get that information to the index committee. And re-entry is also something that we've been working on in the past, and COVID's kind of put a little bit of a hamper on that. So is there any other matters that you guys would like to see brought to any of the future meetings in the Legal and Justice Committee? I see no hands. Is there, which then we can go to public comment. Jill, would you assist me in public comment?
Yes, we have 2 attendees to the meeting at this time. If either of you would like to speak, please virtually raise your hand now. Yeah, no one has a hand raised.
I would like to thank anybody and everybody that's been here participating in this committee, and I think we can call it to adjourn at 12:21 on January 12th, 2021. Thank you and Happy New Year.